Welcome to Law Sutra, your ultimate resource for LLB syllabus support and legal awareness. I am Sachin and I am excited to help you navigate your legal studies and understand the law in a broader context. Our channel offers question and answer videos specifically designed for your LLB syllabus, breaking down complex topics and offering practical insights. But we don't stop there. We also provide essential legal awareness to help you understand how the law impacts everyday life. Got questions about your coursework or curious about how legal concepts apply in real world scenarios? Drop your question in the comments and we will address them in our upcoming videos. Subscribe and hit the notification bell so you never miss an update. Let's master legal studies and enhance our legal awareness together. Our first video is on an incorporation of company and matters incidental thereto question and answer series. Let's start. Our first question is, what are the requirements and provisions for forming a company under the Companies Act 2013? The Companies Act 2013 provides a framework for the formation, regulation, and dissolution of companies in India. It details the processes for incorporating different types of companies, their legal characteristics, and the requirements for their formation. The types of companies and their formation requirements. First one is a public company. Minimum members. 7 or more members are required to form a public company. Maximum members. There is no upper limit on the number of members in a public company. Third one is the public and characteristics. Public companies can offer shares to public and are typically listed on stock exchange. They are subject to stringent regulatory requirements and greater transparency. Next one is a private company. A minimum members, 2 or more members are required to form a private company. Maximum members, the maximum number of members in a private company is capped at 200, excluding present and former employees. Purpose and characteristics. Private companies cannot offer shares to the public. They are subject to less stringent regulatory requirements compared to public companies and often have greater control over their operations. Next one is a one-person company OPC. The minimum requirement of the members is one person can form an OPC. Maximum member or OPC is limited to a single member only. However, the OPC must nominate another person to become a member in the event of original member death or incapacity. Purpose and characteristics. OPCs combine the advantages of a sole proprietorship with the limited liability features of a company. They are ideal for individuals who want to operate a business with a limited liability and are not looking to have multiple shareholders. Specific provisions for one person company. Nominee requirement. The Memorandum of Association of an OPC must specify the name of a person who will become the member if the original subscriber, sole member, dies or become incapacitated. The nominee must provide written consent to act as a member, which must be filled with the Registrar of Companies (ROC) along with the incorporation documents. Next one is consent withdrawal and change of nominee. The nominee's consent can be withdrawn following prescribed procedures. The sole member of an OPC may change the nominee by providing notice to the company. The company is that responsible for the informing the registrar of any changes. Changes in the nominee's name are not considered alteration to the Memorandum of Association. Types of companies based on liability. A company limited by shares. Liability. A member's liability is limited to the amount unpaid on their shares. If the company is wound up, members are only liable to pay for any remaining amount due on their shares. Characteristics. This is the most common type of company and is suitable for the businesses seeking to raise capital by issuing shares. Next one is the company limited by guarantee. Liability. Members' liability is limited to the amount they have agreed to contribute in the event of the company's liquidation. Characteristic often used for non-profit organizations, charitable institutions, and mutual benefit societies. These companies do not issue shares and are not intended to generate profits for distribution to members. Unlimited company. Liability. Members have unlimited liability, meaning their personal asset can be used to cover the company's debt if it is wound up. Characteristics. These companies are less common and typically used where the members wish to avoid the need for disclosure of their financial affairs or where there is a desire for greater flexibility in the company's operation. Now let's see one case laws. It's Bharat Petroleum Corporation versus the Registrar of Companies 2017 overview. This case involved a dispute over the incorporation of a company with specific regulatory conditions. The Supreme Court highlighted the importance of adhering to statutory requirements and the consequences of non-compliance for company formation and registration. Next case is State Bank of India versus Messrs. D. Bharadwaj and Company 2009. Overview. The Supreme Court addressed the issue related to the incorporation of a company limited by guarantee and its implications on the liability of members. The case emphasized the distinction between companies limited by shares and those limited by guarantee, particularly in the terms of member liability. Our next question is short note on Memorandum of Association MOA. Memorandum of Association (MOA) is a fundamental document required for the incorporation of a company under the Companies Act, 2013. It defines the company's constitution and lays down its scope of activities, members' liability, and capital structure. The MOA serves as a charter that governs the company's operations and interactions with the outside world. Key clauses of MOA. Name clause specifies the company's name, which must end with the limited for public companies or private limited for private companies. This clause ensures that the name is not identical or too similar to that of an existing company and does not mislead or imply governmental affiliation. Register office clause states the state in which the company's registered office is located. This determines the jurisdiction and legal framework applicable to the company. Next one is the object clause. Defines the purpose for which the company is formed. This clause is critical as it outlines the activities the company can engage in. Activities outside this object are considered ultra-vires, beyond the power of the company, and are therefore invalid. Next one is the liability clause. Indicates whether the liability of the company's member is limited or unlimited. For companies limited by share, it specifies the extent of the liability concerning unpaid shares. For companies limited by guarantee, it outlines the amount each member agrees to contribute in case of liquidation. Next one is a capital clause. For companies with share capital, this clause details the amount of capital with which the company is to be registered, how it is divided into shares, and the number of shares each subscriber agrees to take. Next one is a one-person company clause. In the case of an OPC, this clause includes the name of person who will become a member if the subscriber dies or is unable to contract. Case laws for the same. Ashbury Railway Carriage and Iron Company versus Ritchie. 1875 overview. This is a landmark case in English company law that established the principle of ultra-vires. The company's MOA includes a clause stating that the company was established for the purpose of manufacturing and selling railway carriages. The company, however, engaged in activity of financing railway schemes that was outside the scope of its MOA. Judgment. The House of Lords held that any act performed by a company that is beyond the scope of its object as defined in the MOA is ultra-vires and therefore void. This case reinforced the principle that companies can only act within the powers conferred upon them by their MOA. Our next question is the short note on Articles of Association AOA definition and purpose. The Article of Association is a document that outlines the internal rules and regulations for the management and administration of a company. It serves as a set of guidelines governing the company's operations, management structure, and the relationship between the company and its shareholders. Key points about Article of Association. First one is regulations for management. The AOA contains regulations that dictate the company's internal management, including procedure for appointing directors, conducting meetings, and handling company finances. Prescribes matters. The AOA must include certain prescribed matters as specified by law, but companies are also free to include additional provisions they deem necessary for their management. Next one is entrenchment provisions. Companies can include entrenchment provisions in their AOA which make it more challenging to amend certain provisions. Such entrenchment clauses can only be added either at the time of company formation or by a special resolution in the case of public company or by unanimous agreement in the case of private company. Next one is the model articles. Companies can adopt model articles provided in the schedules of the Companies Act if the AOA of a newly registered company does not exclude or modify these model articles. They will apply as if they were part of the company's AOA. Notification to registrar. Companies with entrenchment provisions must notify the Registrar of Companies in the prescribed form and manner. Next one is forms and compliances. The AOA must follow specific forms outlined in Table F, G, H, I, and J of Schedule 1 of Companies Act, unless modified by the company. Application to older companies. The provision of the AOA apply to companies registered after the commencement of the Act unless they have been amended under the new Act. Case laws. Hogg versus Cramform Limited, 1967. Overview. In this case, the company's board of directors used their power to issue shares to a new company with the intention of diluting the voting power of a particular shareholder. The company's AOA included a provision that the board could only issue shares for the bona fide business purposes. Judgment. The Court of Appeal held that the director had acted improperly and ultra-vires because their action did not align with the bona fide business purpose required by the AOA. This case underscores the importance of adhering to the provisions set out the AOA and highlight the enforcement of internal regulations. Next case is a BTE and FBT Limited. Overview. This case involved a dispute over the interpretation of the AOA related to the company's management and control. The article specified that a certain decision required the approval of a particular class of shareholders. Judgment. The court ruled that the company's AOA should be strictly adhered and the decision made contrary to the specified requirements were invalid. This case illustrates the principles that companies must act in accordance with their AOA and that provisions within the AOA have binding effect.